presentation from Legal Services Management Service. I've got Chris Reid here who's going to talk about the insurance arrangements for the department activities and how it affects you. We'll start with the legal issues. And the first one is, as teachers, you have a duty of care. And the department holds the duty of care, it holds a non-delegable duty of care. But it employs you to institute that duty of care when it comes to students. So what is it? Well, the first thing is that the courts hold us to a very high standard due to the fact that we're dealing with children, basically. We're dealing with people who aren't adults, often, and have a less formed idea of what will hurt and what won't when they go off and do things. Whether it be risks in the course of the activity or the fact that sometimes kids just do stuff for all the wrong reasons, and we have to be alive to that possibility. So it does lessen as the child gets older and more mature, and the individual characteristics of the students, depending on that. But the duty of care will always be there. And what the duty requires us to do is to take reasonable steps to protect the students from risks that are reasonably foreseeable. And the reasonably bit is very important in there. So we're not giving them or their parents an absolute guarantee of safety, but we are guaranteeing that we have looked at the activities and we have considered that it is safe for the students to participate in, or as safe as we can make it. And the way you work that out is you ask, what would a reasonable person do? And if you've identified the risk, is the risk foreseeable or is it far-fetched and fanciful? There has to be the reasonable element both in the risk and also the treatment that you're going to apply to a risk. If the treatment is way over the top for the risk, then it is not practical and you have to reassess it and work out a new way of dealing with it. So you can't ignore potential hazards. Anything there that will look, in hindsight, I'm afraid, as a foreseeable risk will be accepted as a foreseeable risk, and if we haven't done anything to treat it, we will probably be found liable. So assess the risks and take firm positive action to safeguard the students. Always obviously act in accordance with the department's policies or the policies of the other entities that you work for and the procedures, and always document the actions taken, and that includes, when you've assessed the risk, determine that it is far-fetched and fanciful or not reasonable, or the actions that you would like to take to reduce the risk are not practical. If you've got that documentation, it shows that you've looked at the risk, you've considered the risk, and you've dealt with the risk the best way you can. Now, the principle of vicarious liability operates to say that the employer is liable for the acts of the employee. That goes back to the department has its non-delegable duty of care. It hires teachers and others to provide the teaching to the students, but the department retains the overall responsibility for ensuring that the duty of care is administered in relation to the students. So the common law principle, which is discovered by judges over centuries, is that unless you're acting with serious or willful misconduct, staff are not personally liable for injuries to students. And in New South Wales, that's reinforced by statute law, which is the Employees Liability Act of 1991, which says in relation to negligent acts and omissions of staff, again, provided there is no serious or willful misconduct on part of the staff, that the employer is liable. So unless we get to the points of assault, the employer will be liable. It's really only in those willful and serious cases that the department will step back. Brain fades, decisions taken when adrenaline's running with injured students, things like that, etc., are all covered. We all understand that we're human, and as long as you're dealing with the matters the best that you can, the department retains liability. Now, the work health and safety aspect, or it used to be known as OH&S, they changed it to work health and safety because it's fashionable for governments these days to change the names of everything. but not necessarily change what they do. So the department's obligation is to ensure the health, safety and welfare at work of all employees, of all employees. And that Act extends to the employees in that we have an obligation to ensure health, safety and welfare of each other. So the department's obligation, or the employer's obligation in this case, feeds down through all of the employees. We're all responsible for each other's welfare whilst we're at work, and we all need to note risks or dangers if we can see them and try to ensure that they're reduced. Now, our obligation extends to students and parents and visitors at the sites, and we need to ensure that they're not exposed to risk to their health or safety as well. The students, it's obvious, they're in our care. Parents and other visitors, even contractors at schools or TAFE institutes, may be less clear, but we still have a responsibility as an occupier to ensure that the people who come onto our site are not injured in something that is reasonably obvious. So risk management is the way that we deal with the risks. And the idea of it is that we identify them, we analyse them, we assess them, we work out a treatment, and then we monitor the risk. So if we have a risk assessment in place and we've identified a risk and we thought we've treated it, and a student has an accident, the next step after ensuring the student's okay is to go back and look at how the accident happened and whether we need to amend our treatment of the risk to ensure that it doesn't happen again. And again, that's done on a reasonable basis and a practical basis in that our treatments are able to be done. There's nothing worse than going into court with a risk assessment from the school that says, yes, we heard that risk and we decided that a teacher was going to stand in front of the dangerous area for the entire day to ensure that no students went in there and got injured, whatever it is. Obviously, from a practical point of view, you can't have a member of staff standing in one particular area for the entire time that the school is open. And I think that is just about me, isn't it? So have we got any questions from the legal point of view? That is generally an ongoing thing. Yes, it's possible that you have those areas where the snakes may wander in from located bushland, and the school should have a assessment on it. Obviously, the first one is to the kids. If you see one, don't go near it. And there may be other assessments, like as soon as it's reported, you have a number that the office can ring to get a snake handler in to remove it, whether it's National Park and Wildlife or independent. I don't know about that. But if you are in an area where there is dangerous wildlife, yes, the school should have a policy for how to deal with it when it happens. If the playground is a rough area, I don't know, would you put in institute, first of all, a no running section in that area of the playground because it's rough underfoot? And secondly, maybe the school needs to look at allocating some funds to fixing it. That's a school decision. But if the teacher considers that that area is not fit for the purpose of playing sport in it, then they should report it to the school executive and say, look, we're going to get injuries doing this. I guess from the legal side, the take-home message is that the department remains liable for those who work for the department. The employer remains liable for the actions you take as long as you take the actions in a proper sense, in a well-meaning sense, and that the risks need to be assessed and treated so that we have something to hand up in court to say, well, we did look at that, Your Honour, and we didn't think it was going to be a problem.